Hello.
Hi, Brian. We can hear you.
Okay, good. I'm here. Yay. Hello? Oh,
Hey Brian, can you hear us okay? Yeah.
Brian, can you hear us?
oh yeah, I can hear.
All right, good evening, everybody. 6:01 p.m. This is the regular business meeting of the Smithfield Township Board of Supervisors. Please join me in reciting the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Members present, and myself, Chair Jacob Pride, Vice Chair Robert Levenheim, Supervisor Brian Barrett via Zoom. Engineer Missy Hutchinson is here in person, as is Solicitor Ron Karasak, and Township Manager Julia Hylika. Because of how many folks we have and the swift urgency we need to hear this, we're going to proceed tonight, starting with the public hearing on the Healthy Minds Treatment Center conditional use application. So I will turn it over to our solicitor to begin with the housekeeping remarks before we get into the hearing.
All right, thank you. Good evening, everyone. For those of you who do not know who I am, my name is Ron Karasak, and I am the duly appointed solicitor to Smithfield Township and represent the Township Board of Supervisors in legal matters that come across my desk. My function will be to render legal advice to the Township Board of Supervisors, and that is going to be what I will be doing this evening, because the board will basically be acting as judges, where they will be hearing testimony, they will be examining exhibits. Of course, they can all questions in order to get as much information as necessary to render a decision on the application. Now, before we begin the formal hearing, there are some housekeeping and procedural items that we need to review. First of all, this is a conditional use proceeding, and that means there are certain standards that need to be met. Now, everyone needs to understand whether they agree with this being the law or not. The law is that a conditional use is a permitted use to be granted or denied based upon Township Board of Supervisors decision regarding express standards or criteria that's set forth in the zoning ordinance. And those standards and criteria can be found in section 704 and 705 of the Township zoning ordinance and various subsections thereunder. A conditional use is similar to a special exception use. And those of you who are familiar with township proceedings, a special exception use is a use that is granted, that is heard and then granted by the Township Zoning Hearing Board, where a conditional use is a use heard by the Township Board of Supervisors. And many of the legal standards are exactly the same with respect to a conditional use or a special exception use. The really only major difference is that conditional uses are considered to be of such importance that those decisions should be made by the elected officials who are the Township Board of Supervisors, as opposed to the appointed officials who are the appointed zoning hearing board members. Now, in a conditional use proceeding, there is employed a shifting burden of persuasion or burden of proof. And that's important to understand. The applicant must first persuade the township that the use is of a type permitted and that the use meets the ordinance requirements. And once the applicant does this, the presumption arises that the proposed use is consistent with the general welfare and the use should be granted. The burden of persuasion at that point now shifts to any objectors to rebut that presumption. And they have a very heavy burden of proof. They need to prove to a high degree of probability, and it's a very high standard, that the use adversely affects the public welfare in a way not normally expected to be from that type of use. And there's case law that supports that position. And the township also has the right to reject even uncontradicted testimony if they believe that when I say they, the Board of Supervisors believe that the testimony is credible or worthy of belief. Here, I'm going to give you just a little snippet of the project. What I don't say doesn't mean I'm glossing over it as not important, but I just want to give a little snippet. Here, the project is on behalf of the applicant, Healthy Minds, and where the owner is Water Gap Acquisition Partners, LLC. The project is for a drug, alcohol, and substance abuse residential inpatient treatment facility to be located on a lot of 31.7 acres of the Wolf Hollow Golf Course. And according to the paperwork that was provided, it is to be located on the western side of Potts Gap Road and approximately 100 feet of its intersection with Cherry Valley Road. The project will be a 60-bed facility with a 9,477 square foot two-story building and 60 off-street parking spaces. The facility will be open 24/7. The maximum number of clients will be 60 adults. The length of stay is expected to be from 25 to 40 days. It will be serviced by an on-lot well and an on-lot sanitary sewage system. It's expected that only 2 or 3 bauxite trucks will access the facility 2 or 3 times a week. And the facility must comply with all state and county and local agency rules and regulations. Now, if the project is approved, the Board of Supervisors can attach reasonable conditions and safeguards to the project, in addition to those expressed in the Township zoning ordinance as being necessary to implement the purposes of the State Planning Act or the zoning ordinance. Now, let me spend a minute or two to explain the difference between a public hearing and a public meeting.
Mr. Chair, did you say Healthy Minds Treatment, Healthy Minds Partners LLC? I didn't understand.
The owner is Water Gap Acquisition Partners, LLC.
Well,
The applicant is Healthy Minds Treatment Center.
Healthy Minds Partners LLC, okay.
All right, so a public meeting is a meeting to discuss township business and a meeting open to the public, and if necessary, to take official action on that business. A public hearing is a little different. And that while a public hearing is still a public meeting, its purpose is to inform the public of a potential project and obtain public comment prior to the Board of Supervisors taking official action. The parties or witnesses to a hearing are to testify under oath, and their testimony is being stenographically recorded by the young lady to my left. However, formal rules of evidence do not apply at these proceedings, but immaterial, irrelevant, or non-probative evidence will not be considered. Now, let me explain the difference between a party to the proceedings versus a public commentator. Party, as opposed to a mere public commentator who offers public comment either for or against a project, has a direct, substantial, and immediate interest in the proceedings. That must be more than the general interest that would be common to all township citizens, township taxpayers, and the like. For example, party in this matter could be an adjoining property owner whose use of his or her property could be affected, for example, by traffic or lighting that would be generated by the project. If any person here this evening wants to claim party status and the applicant objects, the Township Board of Supervisors will allow the applicants and/or applicant's attorney to ask questions regarding your party status, so the Township Board of Supervisors can make a determination as to whether or not to grant you that party status. If you are given party status, understand that now makes you a special person, if you will, in the proceedings. You are now a party. You can be questioned by the other lawyers. You can be cross-examined by the other lawyers. You can be asked to review exhibits. You can be questioned by the Township Board of Supervisors, just as any other party to the proceedings. So, the above being said, if anyone wants to request he be given party status or she be given party status, we'll go through those proceedings at the end of these comments. Because if you want to be granted party status and you are given party status, you'll need to come up and fill out what's called a precipice for entry of appearance, that will keep us informed as to who you are, since you would then receive copies of any notices or other proceedings in this case. Anyone else who is not a party is considered a public commentator. And note, there's law to support the position that only township residents or township taxpayers are entitled to offer public comment. However, it's been my experience that the Smithfield Township Board of Supervisors, in the interest of promoting governmental transparency and responsiveness, usually accepts public comment from anyone. And unless this privilege is abused, I don't see that changing for tonight's hearing. You should also know that the Township Planning Commission was required by law to review the application. And the Planning Commission is recommending that the use be granted with the following conditions. Background checks on all staff members for both criminal and sexual misconduct offenses with monitoring by the township. And two, after a designated reasonable curfew, all doors exiting the facility are to have a monitor, alarm, or camera system notifying a central station that there has been a breach and someone has exited the building. Finally, understand that if this use is granted by the Township Board of Supervisors, it doesn't mean that the applicant can stick a shovel in the ground immediately. They must then come before the Board of Supervisors with a land development plan. No different than any other business that wants to build a store or a warehouse or some type of manufacturing building. They have to come with a plan to be reviewed and approved by the Board of Supervisors. So there will be yet one additional step in the approval of this project if in fact the conditional use is approved. So very similar to thinking that in the zoning ordinance, a variance is given for a pizza shop, but then the pizza shop has to come in with plans to show how the shop's going to be built, et cetera, et cetera. So that being said, those are my comments. I'm not sure if the supervisors want to follow up with any comments, and if they do, fine. If not, I'm going to see if anyone wants to be claiming party status so we can proceed in that regard.
The only comment I had is that we intend to go hear this until roughly 2 hours from now, which is, call it 8:15, just so we're conscientious of staff, professionals, or stenographer. That's all I have.
Okay. Which you're entitled to do because you do have other significant other business on the agenda. So, and the public should be aware that if in fact the matter cannot be concluded in the 2 hour period, that the township will then have an additional 45 days to schedule another hearing. Okay, so now, so that being said, other than obviously council is here, so council, if you'd be kind enough to complete the recipe for appearance for me, so that I have that on your end.
I may, can I sit at one of the tables?
Yeah, sure. You want to press the P2, right?
And obviously I have, my client Christine Carroll is here as
Yeah,
well.
okay. Oh, she doesn't have to sign. If you're gonna sign for her, that's fine.
Sure.
All right, while all those councilors signing that document, is there anyone here that wants to be given party status? All right, let's talk in the back there with, I'm not sure if that's Martha or not, or if that's someone else. I can't see it, it's a little too far away. No, it's someone else. Yes. All right, man, can you tell us the basis for which you, well, first of all, let's get your name.
Hi, my name is Diana Scheid, Scheid. I live at 7542 Cherry Valley Road. My property backs up to this proposed site on the golf course.
Can you spell your last name for me again, ma'am?
S is in Sam, Cheid.
You say your property backs up against
Yes,
this property or the project property?
yes, the third fairway, the fifth, formerly the fifth fairway of the golf course.
What about the Fifth Fairway? I'm sorry.
Fifth Fairway ran parallel to my property in the backyard.
Moment. All right, before we see if the supervisors have any questions, does either council have any questions of the young lady with respect to party status?
Good evening, everyone. Amy Farrell with Kaplan Stewart. We are the attorneys for Healthy Minds Partners, the applicant here. Ma'am, I just have one question. Did you receive written notice of this evening's hearing as well?
I was here at the previous meeting of the township, and apparently it was postponed, but, yeah, I was already here. I didn't receive anything in the mail.
Did you receive anything with respect to the prior hearing? Do you remember?
I may have.
Okay. And your property immediately adjoins this property?
Oh, yes.
No objection.
All right, on behalf of supervisors, any
Do you
questions?
need this?
I think we should, define property broadly. In other words, what we found out last week is there are actually 3 properties or something on the part of the golf course. So I think for these purposes, we just say anybody who is, adjacent or backs up to the golf course right here in this way, rather than trying to say it's this property or that property.
Okay. Again, if the applicant has no objection, counsel, you're here on behalf of,
Christine Carroll,
let's get your name for the record too.
Alexander Ward. And I'm from Gross McGinley, the Valentine, PA.
And it's on behalf of, you said Carol,
Christine Carroll,
Christine. with a C.
KR with a K. Actually, 2 Ks.
Okay. And Carol spelled how?
KRISTINE
All right,
KAROL.
okay, thank you. So do you have any questions of Ms. Shy, is that how you say it?
Yeah.
With respect to her having party status?
Just very briefly, what is your concern with respect to tonight's proceedings? Just in a brief way.
Briefly.
Briefly summarize what your concerns are.
Okay, I've been through this once before. The names of the buildings have changed somewhat, but it's still the same players.
Objection, it's actually not. And we haven't put any evidence in yet with respect to this application. It is not an application that was previously heard or may have been heard with respect to this by this board. I'm not sure what we're talking about now in terms of the same players or not.
Well, we're talking about the country club.
Well, let's
now-
do this. I'm gonna overrule or say that that question really isn't relevant for purposes of party status. Right now, party status is simply whether or not you have an interest in this matter.
I
That is
have-
more than the ordinary citizen.
I have an interest.
And there's no objection there,
No,
so. Counsel, all due respect to your question, do you have anything else of this young lady?
No, I don't.
Okay. So, board, do you have any questions? So then we are going to note that Ms. Scheid has been given party status with respect to this matter. All right, now I think there was a young man there. Yes, sir. Your name?
Charles Cohan,
Charles, can you please spell your last name for us?
Cohan.
Okay, and can you tell us why you believe you should be given party status, why you have some rights or concerns that are more than the ordinary citizen?
Yes, I live at 7544 Cherry Valley Road.
Okay,
So my property actually is right next to Diane Shies, and my property sits at the corner of Pascack Road and Cherry Valley Road.
okay, so your property is right next to Ms. Scheid property?
Yeah, so the back portion of my property abuts right against the golf course.
Okay. Attorney Farrell, any questions with respect to Mr. Cohen's request to be given party status?
Mr. Cohen, this same question that I asked Ms. Scheid. Do you recall if you received any written notice of this hearing?
No, I never received any written notice, but I was at the first meeting where which led to this meeting. of the supervisor vote.
Okay, and so you did become aware of this meeting somehow through township notice, whether it was through,
No, I received nothing from township notice. I became aware of this, because of Christine, who's a neighbor of mine.
and your property immediately abuts a portion of the golf course?
Yes, it does.
I have no objection to this point.
All right, council, any questions with respect to party status?
No questions.
And supervisors, any questions? All right, do you believe that Mr. Cohen should be given party status?
Yes.
All right, so then the record should reflect that. Sir, if you.
I actually have one filled out.
You're way ahead of me. Okay. Thank you so much.
If I may hand up my press clear.
Okay. All right. Anyone else requesting party status with respect to this proceeding? All right, the record should reflect no hands are up, so we'll close the record with respect to party status. And before we begin testimony, I'm going to request that various documents be marked into evidence, and I'll see that you guys have copies. We're gonna mark for the record board exhibit number 1. And that is an extension of time request that was signed, allowing the hearing to proceed today, December 13th. Board exhibit number 2 is going to be the advertisements showing that the hearing was advertised in the newspaper for twice a week or once for 2 weeks in a row on November 20 and 30. Board exhibit number 3 is going to be the affidavit of posting. Attached to the back of that is the notice that was posted, showing that the document was posted at the property on November 22, which is more than 7 days prior to the hearing, which would be tonight. And the final document is going to be the township engineer review letter. This is review number 2. And that's it. I think we have them all marked as board exhibits. Is that how we have them? So the board exhibits 1 through 4. And that being said, let me ask Attorney Farrell if you have any objection to those board exhibits.
No objection.
All right, let me ask Attorney Ward, any objection to those exhibits?
No objection.
Let me ask Ms. Scheid, since she's now party, do you have any objection to those board exhibits?
No.
And let me ask Mr. Cohan if he has any objection to those board exhibits.
I do not.
All right, that being said, and the record reflecting that there is no objection to the board exhibits. They are admitted into the record. Give me a moment to catch up.
No, I'm gonna move myself up a little bit.
It's okay. You need a plug?
No, I don't, thank you.
Sure. Okay. And when you're ready, you're ready.
I'm ready.
Okay. So we should also note, I don't have copies, but we'll make them part of the record in one fashion or another. I have 4 recipes for entry of appearance. 1 from Attorney Farrell on behalf of the applicant. 1 from Attorney Ward on behalf of Christine Carroll. 1 on behalf of Diana Scheid in her personal capacity, and 1 on behalf of Charles Cohan in his personal capacity. So again, we'll make those part of the record. What we'll do is I'll note them as board 5 collectively, but I don't have any copies yet at this point. Let's give them the council for the staff. We'll mark it D5 and then. We'll have to pay that D5.
I'm going to say here.
That's your ball. I would do 1, 2, 3. 3 of each. Okay, so we're having the township. All right, so everyone will then have copies of those items. It's about finished here, guys. Okay. Apologize for the delay. And that being said, I will turn the matter over to Attorney Farrell, who can present the matter on behalf of the applicant.
Thank you, Mr. Fairfax, and again, good evening, members of the board, members of the public. Amy Farrell with Kaplan Stewart, as I indicated, we are the attorneys for Healthy Minds Partners LLC, who is the lessee of the property in question and the intended operator of the proposed 60-bed inpatient behavioral health residential drug and alcohol treatment facility on approximately 28 plus acres of property located in the southwest corner of Cherry Valley, Road, on a portion of the former Apollo Country Club. Mr. Karasek did an excellent job of summarizing the condition. So I don't think I have to go through that again for you, other than to simply remind everyone of the sort of general scope of the rules here. Thank you. Which are again that because this has been characterized as a conditional use by the board, it is a use under law that is permitted per se, as long as we as the applicant show that we satisfy the specific and objective criteria of the ordinance. And that's important. It's specific and objective. The clear objective criteria that have been laid out in the ordinance, that's the applicant's burden. Once we've done that, and I will indicate to you tonight to do with this Marley proceeding, that we do in fact meet all of the objective criteria, and the township staff in review of our material confirmed the review that we meet the objective criteria. Once we have done that, as Mr. Karasek indicated, the burden then shifts to any objectors to show through specific and quantifiable evidence that this use is so beyond what you would normally anticipate from this type of use that it can't possibly be what was considered. And again, that's incredibly significant here. It's not as compared to any other use. It is as compared to this use in this setting. Is what's being done or what is being generated so beyond what you would have anticipated with respect to this type of use that it couldn't possibly be what you considered at the time you added it as conditional use. You can understand, and I think as Mr. Karasek indicated, that is an incredibly high burden for objector.
Let me interrupt you for one moment, just to make it further clear to the supervisors. And again, you've been through this before, but I want to make clear. The applicant has to meet certain specific objective criteria that's listed in the ordinance. Once that's done, if there's general criteria like general health and welfare or general safety, you don't have to meet that. That's the burden of the objectors to show that for some reason, to a degree of probability, those general standards can't be met, and they're something that go beyond the normal kin of this project. So again, all the applicant has to do is meet the specific objective criteria of the ordinance with respect to this use.
Thank you. And with respect to those objective criteria, as you this evening, this use is a use that is specifically permitted by conditional use under your ordinance. building coverage permitted under those provisions is 20%, where we're proposing less than 1% building coverage. Maximum impervious coverage of up to 25% is permitted, where we're proposing only just north of 5% impervious coverage. The ordinance would require 59 parking spaces for this use in a building of this size, and we are proposing 60, with additional space on site, should the township deem that additional parking may be advisable. The minimum.
Can I interrupt you? We're going through this, but I need to just be in my notes here a little bit. What was the first thing on whether it was impervious cover or?
The first was maximum building coverage, and again, our engineer will testify to all this in more detail, but
I understand. But
maximum building coverage permitted is 20%, we're proposing less than 1%.
And then you have the impervious.
Impervious was permitted is up to 25%, we're proposing 5.1%.
Okay, I'm sorry to
No
interrupt.
worries, and did you get the parking?
I got the parking.
Minimum lot size for a residential treatment center in this location is 25 acres. We have, north of that, we have 28.7 net acres, 31 gross acres. The services rendered must all occur on site and as confirmed by our project narrative, and as you will hear from the project operator, all services here will be provided for on site. A maximum of 60 persons in treatment at any one time may occupy the property, and we are proposing a 60-bed facility, which means that no more than 60 patients will ever be in treatment at a time. And then I would note there are some additional subjective criteria of the ordinance that the township engineer has reviewed and has confirmed our plan also meets. And again, we'll get into this in more detail, but the township's engineer has reviewed the materials and confirmed that the landscape plan as submitted meets all ordinance requirements, that the lighting plan as submitted meets all ordinance requirements, that adequate provision has been made for treatment and disposal of sewage and the provision of water, that the project narrative and the traffic generation assessment have been reviewed and have been determined to be adequate for ordinance requirements, and that the project is within the allowable limits for steep slope disturbance. Finally, as I think Mr. Karatsev alluded to, we have also received the recommendation of the Township Planning Commission at its November meeting. That is the sum total of what we are required to provide to you in terms of evidence. I do have with me this evening 3 witnesses: Dan Harvey, who's the owner and CEO of Healthy Minds; Chuck Nicholas, who is the civil engineer working on the plans for the treatment center; and Charlie Schmal, who is a senior planner with Urban Research and Development Corporation, who will walk you through in more detail the proposed use and some of those additional criteria. I do also have exhibit packets for you, and I will hand those up if that's okay, Mr. Karatsev, so that you have those as we go. We'll mark those as we go, but they're pre-marked, so we will follow.
We have access to that. Yeah, and then after. Where was the other man?
And the record should reflect that the exhibit packet has been handed to the Board of Supervisors, so the copy given to Attorney Ward, and also copies given to Ms. Bride and Mr. Kennedy.
And with that, unless the board had any immediate questions for me, I would go ahead and call my first witness, Dan Harvey.
All right, Mr. Harvey, please stay, remain standing and to be sworn by this young lady, and then you're welcome to take a seat.
You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Thank you.
Thank you.
Good evening, everybody. My name is Dan Harvey. I'm an owner operator of drug and alcohol rehabs in the United States. I've been doing this for the better part of a decade. I've had relatives die from the disease and I decided to get involved. I started rehab in Georgia that grew to 110 beds. I served 4,000 clients. No fatalities, no significant injuries, never been sued. It was ranked top 10 in the US in rehabs in the United States. That property was sold in 2021. I started with outpatient because there's still significant need in the country. I have 1,500 current clients that are being served for drug and alcohol dependency. And, you know, the problem is not being addressed correctly. And these inpatient facilities are so necessary in this country. Just quickly, 100,000 Americans died in the last year of drug overdose. That is one full 767 jet crashing every day and killing everyone on board. There's a massive need, and I intend to fill the need. In a beautiful town like this, nature plays a big role in recovery. Studies say it brings down the stress hormone, less cravings, and it's just a great way to recover. And I think these people, some of the people have the misconception that these people will be on that train, the zombie drug, and they're that's not it. It's PTA mothers that are alcoholics. It's the mailman that's addicted to Valium. And then unfortunately, there's a lot of young people on their parents' insurance that are addicted to heroin. But these people deserve a chance and a safe place to heal. And I'm a seasoned operator. I love doing it. And I worked 6 days a week, 14 hours a day when I had the inpatient. And I like to get back into it to give back to these people that are suffering with this disease.
Yeah. I would note for the board, as I indicated, we did hand up an exhibit packet. We will be going through these in the beginning, just by way of background of the housekeeping. At applicant A1 is a copy of the application, project narrative, and initial plan set as submitted initially with this application just for reference. And at A2 is a deed and the redacted lease agreement for this property. And Dan, with respect to applicant's exhibit 2, the redacted lease in particular, Healthy Minds has entered into a lease for this property. Is that correct?
That is correct.
Now, we've gone through a bit about what compelled you, I think, to want to get back into this field and reopen a facility. You talked a little bit as well about your experience with many of the folks that you helped previously. We have included at applicants a series of some testimonials that were prepared and sent to you. Can you just speak a little bit to the board about what those were? And you don't have to go into great detail, just a sense of sort of where those came from.
Yes, I had over 100 letters that I kept personally from family members and people who went through the drug and alcohol rehab, about success stories, how they feel, what they're doing in life now, and the burden that's been lifted from their shoulders, their family shoulders. Yeah, I mean, this affects an entire community, and the success stories are amazing, amazing.
Now, as we heard from residents during the planning commission meeting on this application, and I think this was alluded to a bit by one of the individuals who was seeking party status, there is or was an application related to another potential rehab facility on a nearby property in this township. And certainly at the planning commission, there seems to be some confusion among the residents as to whether or not you were involved in that project. Were you involved in any way in any other project or proposal for a rehabilitation facility in the township?
No, I'm not.
And you're also not currently involved in any other project for a rehabilitation center in the township, is that right?
I'm not.
And Healthy Minds, which is the entity that you established to operate this treatment center, Was that entity in any way involved, or is that entity in any way involved in that other operation?
It is not.
Now, with respect to this proposal, will it require any specialized licensing through the Commonwealth of Pennsylvania?
Yes, DHS and EPAT.
And
And on the record, you can just say what those acronyms are.
Yeah, Department of Health Services in Pennsylvania. And the Department of Drug and Alcohol Projects in Pennsylvania.
Thank you.
And can you just speak a little bit to what they're looking at, what they review in terms of your, the building, the operations, et cetera?
Right, so they set the guidelines of the rules and regulations of the day-to-day operations of the business, and safety being first and foremost. So, you know, when a family member drops someone off at the rehab, the best I can do, the lowest common denominator is to promise that I'll keep that person safe. And then after that, you start to work on it. So we follow these guidelines to make sure people are safe, that, you know, you have cameras, that you've got smoke alarms, that you've got the proper program, that you've got licensed personnel, properly licensed mental health counselors, psychiatrists, nurses. And so they set the standard.
And you're obligated then, to, as part of that licensing, to submit to all those standards, and I'm assuming there's periodic inspections and other things that go along with that.
Yeah, so once a year from the state would visit, certainly, and then there's surprise visits, unannounced, at least once a year.
Now, we've included, in the board's exhibit packet at applicants for, an aerial, of the general location, for the proposed treatment facility, as well as the surrounding area. And you spoke a little bit of this, I think, in your opening, but can you just speak a bit further into why it is that you felt that this was an appropriate, and useful, suitable location, for a facility of this type?
Yeah, I mean, outside of an urban setting, a rural setting is certainly better for people that are trying to kick drugs and alcohol. There's less temptation, and just nature's got a way to heal, and the studies will tell you, again, lower stress hormones, less cravings. And but one of the big factors is not being an urban setting is having available drugs nearby.
And in a setting like this where you have as much property as you leased, you're almost 30 acres, does it allow you a level of screening and privacy, et cetera, that you might not otherwise find on other sites?
Yeah, I mean, that's important. I know the people of the town are worried about their own property and their own privacy, but the people that are in these institutions are, that they have private insurance. And they want privacy as well, because many people will be from the surrounding towns. And so they don't necessarily want people to know that they're in drug and alcohol rehab. So they're there for a specific reason, to heal, to get better, to get back to the family, to get back to their job. And so, yeah, I think it works very well. The town, and I mean, the fact is, Summit, New Jersey has Summit Ridge. It's been there 25 years as a drug and alcohol rehab. There's a beautiful one in New Canaan, Connecticut, Silver Hill, with promises in Malibu. I mean, these people that go to these facilities, private facilities, they respect the town, they respect the townsfolk. They're not here to raise havoc. They're here to get better.
Now, at the planning commission meeting, there was also some concern raised by a few residents, with respect to the adjacency to the private golf course. And, you had an opportunity to speak with the owner operator of that golf course to get a little more detail on, what type of operation that is. Can you just give a little more detail with respect to how that, golf course is currently operating, please?
Yeah, so Sean Lyon was the original owner of the golf course and the banquet hall. He's a friend of mine. They're doing 100 rounds a year there. At $25 a pop, so that's $2,500 is their gross income revenue from the golf course over the last year. It's not a viable business. So, we're not interfering with the viable business. And also the, people that come out and play, they are not, they use a company golf cart and there's no drugs or alcohol allowed. So there's no drinking while playing golf.
And in fact, we've included applicants by, some images from, the water gap golf, website, which actually indicate right on it that it is an alcohol-free, golf course. Is that right?
That is correct.
Now, with respect to the facility itself, let's talk a bit about, the operations specifically. Can you speak to what type of clients, will be, seeking treatment or service at this location?
Yes. 80% will have private insurance through their employer, Cigna, Aetna, Blue Cross Blue Shield. The rest would likely be cash pay. And then we leave some for military personnel. But just in the business of drug and alcohol rehabilitation. 2/3 will skew men, 1/3 women. 40% will be alcoholics and the rest will be polysubstance, other different substances.
Now, are these, at this location, are all of the clients over the age of 18?
Yes,
And do you perform health screening, criminal background checks and the like before you would admit someone?
yes, so there's no court order. And then we would do a background check for a violent past, yeah.
So when you say not court ordered, you mean that everyone who's here is voluntarily seeking treatment? Now you said you mentioned clients that will have had to pass, health and criminal background checks. And again, we spoke a bit about this, at the planning commission meeting. And they requested or suggested, a condition, that you were amenable to, that both clients and staff, would be subject to, background checks, and anyone who was convicted of a violent felony or a sexual offense, the Megan's Law offense, would be screened out from this location. Is that right?
Correct.
What about if you have somebody who you think needs either acute medical care, or might otherwise have an increased, need for oversight or management? Do you treat that type of individual at this location?
I mean, it'll be up to the clinical director to make that decision, who is trained in this, but again, there could be disciplinary action and voluntary dismissal. If people, everyone's in there for the same reason, and if you have someone that's disrupting the environment and hurting people's attempt at sobriety, they have to go.
And I mentioned it in my opening, but just so that the record's clear, how many beds are proposed for this facility?
66 here.
And can you provide a general overview of how the treatment center will operate this?
An average day at the.
Sure, in terms of how client intake through, through a typical day for that.
So, a family would drive up through a gate, drop off the person struggling with drugs or alcohol, and we would do a medical exam and do some vitals, admit the person. The family would then, of course, leave. They would then partake in our programming, which is vital and also necessary for if you want to be reimbursed by insurance. But it would be breakfast 7 to 9, 9 to 12 mandatory classroom in group, 12 to 1 week lunch, 1 to 5 mandatory group again, and likely one-on-one with a therapist. Once a week, they would meet with their psychiatrist or psychiatric nurse practitioner. And then dinner and then programming 7 to 9, and then a curfew.
And are clients in this, at this facility permitted to have vehicles?
No, not their own vehicle, no.
And do they have any outside, employment or schooling that they're permitted to go to, during the day, or are they?
Not with an inpatient facility, no, they're there for the duration.
With respect to visitation, are families permitted, to visit throughout the treatment, and if so, how does that work?
Now, you can hatch this out, but it's successful is once every other weekend, either a Saturday or Sunday, the family's allowed to come up. The family gets programming as well. The family needs counseling as well, why their loved one is in the condition that they are and how they can heal.
Once someone successfully, let's focus first on successfully completing the program. When somebody successfully completes the program, what does that discharge process look like?
So insurance dictates how long the length of stay. And so insurance is really set the precedent for the 30-day stay. So they would stay for 30 days, get their programming. And then you'd have a medical professional discharge them and taking the vitals, making sure that if they leave with any medications. And then they'd have a family member pick them up at the facility and take them home. Now, because there's so many people in the community that are in sobriety, you know, you have alumni days once a quarter that would likely be off campus. Like just a sense of camaraderie, whatever, we're putting together. And I think it's important to go. And then you see the current patients see these successes and they can see themselves in those shoes in 2 months, 6 months, 8 months, what it looks like to be untapped of the disease.
Can you speak a bit to the use of medication at the treatment center? I'm assuming there are situations where either there's medication that is prescribed as part of the treatment program, or there are individuals who are otherwise on medication. How is that managed? So
studies show that medication-assisted treatment has a better outcome with addiction. And so things like Vivitrol for alcohol, which is time released, and there's in hindquarters, or Sublocade, time released for heroin and other opioids, goes in the stomach. And the reason you give the shot is because it can't be abused. And it's time release, you can't share it, you can't cheat it. And it's very effective for cutting down cravings. And so we intend on using both at Healthy Minds. And how does that treatment protocol work in terms of the delivery of those needed medical support medications? Is it supervised? Is there a nurse? How does that work? Yeah, I mean, you're not going to give yourself this Sublocade shot is big. I mean, bigger than that. But yes, it would come delivered that day, kept in a lockbox, and then given by a medical professional. But yeah, this is not a small needle. And with respect to any other prescription medications that a patient may be on, are those also administered monitored by a professional rather than or just an individual? How does that work? Yeah, and the state has to be behind 3 locked doors. So there would be the locked door of the facility, then a nursing station, and then behind a wall of the nursing station. All very vital so people can't get to the medication they have to take. And then the nurse would then look at the chart and then decipher what medication the person needs and then hand them the medication and watch them take the medication. Is methadone used in any way or for any reason at this facility? Yeah.
Now, you described a bit, for the board earlier, what a sort of typical day, for, a client or a patient might look like. Are there breaks built into that day or, personal time built into those days, or how does that work generally?
Right, so insurance dictates the day to day. So you're gonna need 7 to 8 hours of programming depending on what insurance you have. So it is a very busy day, keeping them busy, but there are breaks, there's a break for lunch, there's a break after dinner. But it's a very busy day, you gotta keep them busy as well. There's a lot of programming going on and it's mandatory.
In addition to this, to what sounds like a very structured schedule, are there also other, rules that patients are required to follow while they're in treatment?
Could you clarify that for me?
I'm just wondering if there, do you have regulations with respect to, interaction among patients and how we're treating each other, or whether people can smoke or not, within the building or on campus, those sort of day-to-day rules and regulations that you might have outside of a structured treatment schedule.
Yeah, I mean, there's a large book of policy and procedures. I'd be happy to share with anyone that would like to see it. It's already completed, but there's plenty of rules, plenty of rules.
And what happens if, an individual violates, one or more of the rules?
Again, that would be up to a clinical team about what happens next, because you want to keep them at the facility to know that they're safe. So you have to go above and beyond if you actually get dismissed from one of these programs. But again, you got to worry about everyone else's sobriety as well. So it is a hard call, but it's a very difficult business with high-risk individuals.
So there are some situations I'm assuming in which it's, might be considered a minor infraction, for example, that would not lead to discharge, but others that, if I'm understanding you correctly, the clinical team might determine did warrant discharge. Is that fair?
Yes, absolutely.
And if that clinical team did determine discharge is necessary, there's a process in place for how that happens. You don't just open the gate and send them on their way, right?
No, of course. You call the family, if the family's not able to do it, you get them to, you have a driver that go within 60 miles to take them where they're going. But certainly not open the door and have them exit.
So there's always some system in place for somebody who is being discharged, whether it's to family or to get them to somewhere so that they can get where they need to be. Now, you mentioned a variety of sort of clinical staff when you were summarizing the treatments for the board. Can you describe generally the amount and level of staffing and the types of staffing that you're anticipating at this facility?
Yes, so for the state of Pennsylvania, you need a psychiatrist, a board certified psychiatrist. You'd likely have a few psychiatric nurse practitioners to work under that psychiatrist. And then you have a whole host of RNs, LPNs, techs that are helping patients day to day, cooks, chefs, cleaning people, grounds crew. So you could have 70, 80 full-time employees. The median salary would be above $60,000 with benefits year round.
And that's not 70 to 80 employees on site.
At one site.
Do you have a sense yet of sort of how those shifts might work?
Yeah, I mean, 9 to 5, Monday through Friday would be the busiest time, right? Because you have people in accounting, human resources and whatnot at those times. But yes, the shift would be 2 12-hour shifts throughout the week, with the weekends.
Now you alluded to it a bit earlier with respect to some of the state requirements with respect to cameras and security. Can you speak a bit to the security on site and what the various security measures are?
Right, I mean, the beauty of this is it's a brand new facility if it's approved. And it would be state of the art. with cameras and alarms and many other safeguards to keep the people safe, both inside and outside of the facility. So when you can build something from scratch, you know, it would be superior than retrofitting a building, so it's gonna be a magnificent building.
Now, with respect to, some of the discussion that we had at the planning commission and with some of the residents there, we spoke to, or discussed some conditions, of, approval that the planning commission, asked us about, and that we certainly indicated to them that we would, be open to and amenable to, and would, discuss with this board as well. And I just wanted to go through those to confirm, one more time, the items that, based on that planning commission discussion, you have already agreed that you would, some of these you already were doing anyways, but that, just to confirm that there are things that you would be doing here. One is the mandatory background checks, for both staff and clients, is that correct?
Staff certainly, clients, yes, I will say, the nature of the disease, you know, people have DWIs, reckless driving, so they're not unblemished, but yes, violent crimes, yes.
And with respect to those background checks, and then both the staff and the clients, you would not be accepting, staff or clients that have been convicted of a violent felony or a sexual offense, right? Those folks were treated at other facilities, right? And, you also indicated that you would not be accepting, court-ordered, attend clients at this facility, right?
Right, be 100% voluntary, no quarter.
We also spoke with the planning commission and residents at that time about, a little more specifically with respect to security, specifically that, we will be installing a gate at the entrance, to the facility, correct?
Yes,
And, that there will be provision for overnight security as well as, silent door alarms, on the exit doors with, cameras and lighting that notify, essential security if there were to be somebody that, you know, the door after the correct?
right.
And finally, we did speak a bit about, helping to delineate a bit, as much for the residents of this facility as others, this facility versus, surrounding golf course. And we did talk about, looking into, you know, a split rail fence or something, similar that we would work with the township on, during land development for this to be approved, to determine exactly sort of how and where that should be, or you're still amenable to installing something similar.
Happy to.
And of course, with respect to this board, given that they just missed this evening, they may have additional, conditions or questions. I'm assuming that you would be open to discussion as to those additional conditions as well.
I would.
And, our engineer will get into more of the specifics with respect to the dimensional requirements of the ordinance and how we meet all of those things. And I think you have generally summarized already for this board, some of the positives, with respect to, this facility. But if you can speak again, just sort of generally as to, what you see as the positive benefits, of a facility like this, to the township. So not just to the clients that you're treating, but to the township, in general.
I mean, the need is there. We can all agree that the need is there in the country. So you can bring a facility, there's some bad actors in this business as well. I've seen many of them. So you bring in a seasoned operator that can build a state-of-the-art facility. And there's a lot of people in the town and surrounding towns will either be treated at the facility or work at the facility. It's a great place to work. It is, in this business, is very purposeful life. You know, you're out doing something and helping another human being. So it's a great thing to get involved in. And I think for the town, again, I talked about the 7 or 8 full-time jobs, good pay. Yeah, I think it's a symbiotic relationship really between the town and a facility like this. You'd be very surprised how many people in the town will wind up being helped by this thing.
I have no additional questions for the end at this time.
Right, Mr. Chair, with your permission, I would suggest we go to Attorney Ward to see if he has any questions. Then we would go to Ms. Scheid and Mr. Cohan to see if any questions, and then finish up with any questions by board members. So if that meets with your approval, then first check with our stenographer, are we good? Okay. All right, then Attorney Ward, you're on.
Thank you. So Mr. Harvey, can you tell me please, what was it that you did before you got into the recovery field?
Section relevance?
If we don't go too far afield, I would say that I'll overrule that objection for right now.
I was in finance.
Okay, and how was it that you decided to get into the recovery area?
I put a live-in girlfriend in Silver Hill in Connecticut for cocaine and alcohol.
Okay, and that was what led you to opening a facility in Georgia?
That is correct.
Okay, and when you did that, did you give up your career in finance?
I did.
Okay, when did you first start operating the facility in Georgia?
2016.
2016, did you take any sort of background courses or develop any sort of training or expertise in running a facility before you began operating the Georgia facility?
Yes.
What did you do in that regard, sir?
It's mandatory courses in Georgia. We gotta take JCO courses as well.
Again, sir, if you could just say what the acronym is.
Yes, sorry, joint commission. Hospitals have to go through it, rehabs have to go through it. Long-term care facilities have to go through it. So that's a third party. To give accreditation. That's very well known, and it's additional. Safeguard. That layers nicely with what the state and the federal government require you to do in a business like this.
What specifically did that entail?
Which part?
The background training that you got before you opened the Georgia unit.
Yeah, I mean, just the general CPR, man or woman down, drug interaction. Yeah, I mean, all kinds of emergency situations that you're trained for. The state of Georgia mandated it as well. And so did JCO for that matter.
Can you give me an estimate of how many hours you have spent total in your background training? 50 hours? Do you have any certificates or anything as a result of that?
At the time, yes.
Have you kept up on that?
No.
Why not, sir?
Because now I'm doing outpatient 1,500 clients. It's not necessary.
Okay, so the outpatient 1,500 clients, is that in Georgia?
It is.
Okay. And I think you said you're up to 4,000 clients there now?
I treated 4,000 people at the inpatient. I'm at 1,500 currently at the outpatient.
Okay, and it's your testimony that you've never had a single injury during the entire time that you're involved in rehab?
Significant injury? No, I have not.
How about deaths?
Never,
Never had a death?
never.
Do you attribute that to your programs that you have in place?
And I spent all my waking hours there to make sure people were safe, yes.
Okay. You'll agree with me though, sir, that the recovery rate from things such as polysubstance is not very high in this country, is it?
Objection, can we narrow that a little? I don't know what not very high means. You have.
Well, okay, so how about opiate reduction, recovery? What's the nationwide rate, if you know, for recovery from opiate reduction?
I mean, it depends on the study, really. And is it voluntary? You do medication assisted treatment. You know, it's all over the map.
Does 5 to 10% sound right to you, sir?
It doesn't.
That's
Not voluntary, not medication assisted treatment, it's way off.
Okay, so your rate of recovery is dramatically higher than 5 to 10%?
Absolutely, yes.
You have research to support that,
I
sir?
do.
You did,
Mhm.
okay. Now, you mentioned that you have security in your facility, correct?
Yes.
But security can't prevent all drugs from being moved into the facility, isn't that right?
You can answer it if you know.
People are very clever. If they want to try to sneak it in, they're gonna give it a shot.
Right, they can get, anyone, anywhere, anytime can get drugs if they really want them, correct?
Anyone, anywhere, anytime, in a facility, I would say no.
No, not even,
Anyone, anywhere, anytime, that's false.
that's false in your mind? Okay, so, okay, very well. They could certainly get alcohol though, correct?
And how would they do it?
Well, I'm asking you, sir, they could get alcohol, could they not?
I mean, they're gonna bring in what? First of all, where would they get it? And they bring it to the front door?
Oh, they have visitors, don't they, sir?
Yeah, everyone's checked.
Hold on, is this probative? Anybody could ask a question about these things.
Right, I mean, I'm giving a little
It's
bit of,
very specific, or
we're
it's
starting to
very
get,
broad.
So is there an objection to the last question, or is there an objection to this line of questioning generally, just so I know where we are?
well, candidly, I was giving him a little bit of leeway. I think that the chairman has sort of hit on the concern here. As we indicated at the start, you know, his questions are anyone, anywhere, anytime. That's true of any facility. So I think we need to be specific as to this facility with respect to the line.
I think council is attempting to establish that when your testimony was that there will be no drugs and no alcohol. He wants to establish the fact that, as you just said, that can occur anywhere at any time in a facility. If you agree to that, then I think this question has been answered.
Well, I think Dan has specifically disagreed with that, right? On the record has said he doesn't agree that it's anywhere, anytime, anyone.
Well, then, I think the question is proper. If he disagrees with it, then he's got to move on.
It's not my fault.
Now, you mentioned, sir, that you are gonna be treating people with mental illness, correct?
Part of the disease, yes.
Well, are you talking about people with both mental health and substance abuse issues, or just people with mental health? In other words, are these all people with either co-occurring disorders or just substance abuse issues, or is there also mental health by itself?
It'd be primary substance abuse. That would have, the license would be primary substance.
Some of these individuals would be at risk of harming themselves, though, correct?
Of harming themselves?
Yes.
Correct.
And some of them would probably be at risk of something like committing suicide, correct?
Objection, I'm gonna object again. We're talking generally about what would happen in any facility, and that's not the standard here. He's not asking questions about what specifically would be in place here. He's talking about this could happen anywhere.
But for the record, I've never had a death. And, but you're dealing with a high-risk population.
Correct.
It's the nature.
And that's why you have among your requirements in your application that people are not permitted to have things like straight edge razors, correct?
Correct,
And they're not allowed to have aerosol cans, correct?
correct,
And they can't have any sort of aftershave that might have alcohol in it, correct?
correct.
Because they can abuse those substances, correct? Okay, people who are alcoholics or drug addicts or desperate people could do things like that, correct? And those would be the kind of people to be treated, correct, sir? Okay.
Let me get back to your objection. I'm gonna overrule it just in the interest of the fact that I think the question's been asked and answered. But if there's something that is asked that is something to which Mr. Harvey does not agree, it simply says that, I don't agree with it, and Mr. Ward then needs to move on.
Okay, fair enough, I will. I don't mean to belabor this particular topic, it's just that Mr. Harvey talked, and sir, you agree, you talked a lot about the success stories, correct? But there's another side to that too, right?
I mean, not everyone succeeds in many things in life, correct?
Okay, but in recovery, the rate of failure is much higher than the rate of success, isn't it, sir?
It depends, again, if it's voluntary and using medication assisted treatment, it's higher than what you're talking about, much higher.
Okay, and so you use the term voluntary, what specifically do you mean by voluntary?
You can re-answer the same way that you answered previously.
Not court order. So court doesn't say you must enter this program or you're going to jail.
Okay, but it could be someone that would go there, say, after a family intervention, correct?
That is correct.
Someone that was going there because their spouse said, either you go to treatment or I'm gonna divorce you, correct?
Yeah,
You would take those kind of people?
definitely, yes.
And you mentioned that, there was both private insurance and cash, clients, is that correct?
Correct.
What would the cash client be paying for a stay at your facility?
Objection, relevance. Has absolutely no bearing on the operation of this facility, how much a private pay is paying.
Testimony about insurance and cash, et cetera, so I think he can ask this one question as to what that is. If Mr. Harvey knows, he doesn't know, then he's got to move on.
I mean, I know nationwide, cash pay at an inpatient drug and alcohol rehab, voluntary is $800 a night.
$800 a night? Now, you mentioned the importance of having a seasoned operator to run your facility. Do you have a seasoned operator in mind?
Yes,
Can you tell us who that person is?
me.
You. So it's your intention to be on site the entire time?
I mean, the
Facility
entire
operator?
time. The majority of the time, yes,
This is a 24/7 facility, correct?
it is.
24/7, 365, correct?
Mhm.
So some of the time you'll be there operating the facility, correct?
Mhm.
And some of the time you won't be.
Yeah, but I mean, as I said, I put in 6 days a week in my last facility and I'm ready to do it again.
Who's gonna be operating the facility when you're not operating it?
Yeah, I mean, that, I don't know at this moment.
You don't have the answer to that? So, sir, why did you choose this specific location to have your rehab facility?
Yeah. I'm familiar with the area. My friend Sean Lyon used to own the property 3 years ago. Yeah, and I think it's a great place for people to get sober.
Okay, and your testimony was that you had no connection with the other facility that's operating, the Delaware Gap Wellness Facility?
No,
You know an individual named Joseph Slim?
Objection, relevance.
And there was testimony that he was not connected with the water gap facility, so again, I think they can ask one or two questions with respect to that.
You know, Joe?
yes, I do know Dan.
What is your connection with Joseph Slim?
Again, objection, relevance. What does this have to do with the operation of this facility? We've already indicated multiple times that this facility and this operator has nothing to do with the other operation at the other facility.
Can you provide the township and offer proof with respect to this question?
Sure, I am holding in my hand a copy of a registration of fictitious name application from 2018. The fictitious name is Water Gap Wellness. The applicant is an individual named Joseph Flynn. And on the reverse of that, the individual who is authorized to execute amendments, withdrawals, or cancellation of the registration is an individual named Dan Harvey. Now, as I'm sure the solicitor is aware, Joseph Schlem is the individual who operated the previous facility, the Water Gap Capital Partners LLC applicant that had a previous curative amendment for this body, which was approved and then later denied or rejected by the trial court on the grounds that the facility did present a greater than normal danger to the community based upon the way that facility is operated. So I'm simply asking if there's a connection between this individual and the other individual, Joseph Flynn, who operated a dangerous facility for the trial court and the Commonwealth Court.
If you want to ask whether or not Mr. Harvey signed that fictitious name application, et cetera, or that he's designated as someone who can do amendments, et cetera, that he can answer. Anything else has nothing to do with this matter and it's the thing.
I understand.
So you can ask that question, if in fact. Mr. Harvey, either signed or as part of that petition.
May I just show how a copy of it?
Sure, go right ahead.
And I've already identified this for the hearing, but you can just take a minute and look that over.
You have that as a hearing exhibit at the.
I can use it. It will be objectors one. We have another copy of that.
I can have another copy of that.
And sir, if you could just look at the second page, please. Can you see your name on there?
I do.
Does that refer to you?
It must.
Do you have any reason to believe it's not you?
I don't.
You recall your involvement with this?
I was never involved with the project, never had any discussions about the project. No.
So do you know how your name got on that document?
I do know the other person on this.
My question, do you know how your name
No
got on
idea.
that document?
No, I,
Not your signature, and you did not in any way countersign that name.
no,
So your answer would be no, you don't know how your name got on that
I
document.
don't.
Okay. And again, the attorney word, I'm sorry, what's that document? Again, a fictitious name, amendment or application, just so.
Registration. Pennsylvania Department of State Bureau of Corporations and Charitable Organizations, registration of the Texas name
Got it.
dated 2018, 11/20/2018.
Okay.
You have a copy of that, Mr. Ward?
Not sure how this works, so I just hand it up to you.
Not that formal.
You're not standing on any formality.
We'll get to it. You don't have any current characters else, just to.
I'm just the appointed schlub. They're the elected officials.
Is this copy for me to keep?
You can keep that.
Do we have a copy that can be removed as well?
Ask you, but who's Michael Burke? Know who Michael Burke is?
Yeah, he was a coworker of mine 15 years ago.
Still moving on.
I could, so some questions about the, your statement of community impact. And you basically stated your application, the proposed use will not have a detrimental impact on adjacent properties. And then it says the new use does not produce a significant negative impact on the property values of adjacent properties, nor does it produce potential nuisance impacts related to noise, odors, vibrations, or glare. If I can just take start with the first part of that. The new use does not produce a significant negative impact on the property values of adjacent properties. What's the basis for that assertion?
Give me one second, I just want to. I believe that under the generally objective criteria, in which case, or the general criteria, not the specifically objective criteria, in which case I would object generally to testimony along those lines.
It's in your package. If you know. Did that, I don't get involved in determining fair market value, and then that's the thing. You don't have to answer something that you don't have the information for.
If you know the answer to that question or where that's, I just want to have answers.
I don't know.
Have you done any research into the potential impact of a residential treatment facility on property values?
Again, if you've personally done or not.
That I sustain, he just doesn't know where that,
Okay,
the answer to that question as to property value.
I appreciate that. I'll move on. And then the second part says, nor does it create potential nuisance impacts related to noise, odors, vibrations, or glare. What's the basis for that assertion?
And again, yeah, if you know.
I mean, one of the aspects was the signage that we were warned about. You know, not to have a large sign, to have something that is less conspicuous. And that's part of the glare in that statement.
So other than signage, is there any other sort of justification and basis for that assertion?
Can you repeat that assertion?
Where you say, in the second part, I'm looking under community impacts, nor does it create, and this is referring to the treatment center, nor does it create potential nuisance impacts related to noise, odors, vibrations, or glare. And my question to you is, other than the signage, where you said you had to reduce your limited sign, is there any other justification and basis for that statement?
And again, just to your knowledge.
Right. I mean, the building itself, the way it is built, soundproofing is less than any kind of noise disturbances.
Are the residents allowed outside during the day?
Are they allowed outside? Yes, they're allowed to break. I mean, they're regular people, right? So they are able to get some fresh air.
So obviously the soundproofing in the building wouldn't have any impact with that one, correct?
To the extent, you know.
The building, correct.
Are there any other justifications for your assertion, other than the lack of signage and the soundproofing?
No.
Now, I think you have familiarity with the traffic study.
We have an engineer who will be testifying as to the engineering aspect.
Okay. I'm just gonna- Okay, and then with respect to, I believe you testified that you intend to have MAT, medically assisted treatment.
Mhm.
Okay, and that has to be administered by a doctor.
Mhm.
Will it be a doctor on call 24/7?
Yes.
Thank you.
Sorry.
And your question again?
Would there be a doctor on call 24/7?
On call, yes.
Not at the scene?
Not 24/7, but every day of the week.
Okay, do you anticipate any need for sort of police involvement with your facility?
I don't.
If there was a need for police involvement, how would that be taken care of?
I mean, the policies and procedures for that, but there'd be security on campus. And if it's something they couldn't take care of, they would call the authorities.
And she go first. Sir, I'm handing you a copy of what has been represented to me is a copy of 911 calls from your Georgia facility. Mind taking look through that for me, please?
That's going to be an exhibit, council.
It will, if you confirm that it is what we are representing it to be. Okay. Mr. Harvey, I don't have any specific questions for you about that document just yet. Would you agree with me that that is in fact a copy of a 911 call from your Georgia facility?
I mean, I have no idea. If you say it is, it is.
That's not the question. Do you know if that's,
Absolutely.
and you can't ask any questions about it unless we have independent proof.
Okay, understand. Let's see that back. So can I just ask you, sir, are you familiar with your application, sort of the engineering reports as well as your project narrative that it's listed consistently as 33.74 acres of land?
Again, we have an engineer who's going to be testifying as to the engineering documents and information related to acreage.
Well, I think you could answer that one question if he's familiar with the fact that 33.74
Correct.
acres, again, if he knows, he can answer that question, I don't think that's. And we understand being an engineer, et cetera, that will later about that, so he wants to know. if Mr. Harvey knows that or not.
I am familiar.
Okay, is that the accurate acreage of the project?
But like you'd have to ask the engineer. I mean, I didn't measure it.
Okay. You can't tell us whether 33.74 is the accurate figure?
Ask and answer.
Yeah, I think he said that he would have that, that's the engineers, but I was just saying that's the.
Thanks, Ben.
So we do not have you redirect and then go back and forth. We have all the questions asked on cross or not cross, but all the questions asked by parties and the board. And then if you have any redirect, we go.
Okay. No question.
All right, so we're gonna go to now, Ms. Shy, do you have any questions with respect to this gentleman regarding what he testified to? You cannot bring out something that he testified to. You've got to be focused on what he said on the record examination. Do you have any questions other than that?
Yeah, just. a couple.
Okay, stand up so that
Yep.
we can hear you and the
Yeah.
stand up can hear you, and then you come up to the.
Sure.
understand that you're not a lawyer, so that you may have difficulty answering some of it or asking questions. We'll do our best to try to help you, but if there's something that's improper, I'm gonna tell you.
Sure.
Go ahead.
Who at this time actually owns the property of the 9 holes of the golf course?
And what's going to be involved?
I mean, the John Lyons still own
That's
it?
not part of it, yes. He's a partner in the ownership of the structure. We are water gap acquisition partners. Tron Line is part of it.
And he's going to remain an owner of the property if it's approved by the township when you're buying the property
I
from
would
him?
buy that acreage, yes.
Okay, the surrounding acreage, because it's just not the 33 acres, he would still own that part of the golf course, but it wouldn't be operated as a golf course.
No. No,
So there will be no more golf course whatsoever, whether it's on the west, the east side of Pascagoula, or the west side of Pascagoula.
I mean, they're talking about some fencing to be able to play around it. I can't make that definitive statement, but they're talking about keeping it open, have some fencing around that hole.
Have so many questions because, I mean, I live right there. And I can imagine at night, there's going to be tall lights surrounding a huge parking lot, which going to myself will definitely be glared into our homes because we're that close. That's a big concern to me. The other concern I have is with, I'm good.
We're gonna have to take the questions. Not concerns, like you have to ask him a question, I wouldn't say the question already.
Well, I would probably, the question, not so much to yourself, but maybe to your engineer.
All right, well, then
Yeah,
if
right.
you're satisfied, then you're welcome to ask that question to the engineer. I was going to say that
Not at this time,
a light glare would probably be the question to the engineer.
right?
So you can still ask it, but not to this gentleman because the engineer is going to testify.
I just want to know from, I know not all the township supervisors are here tonight.
It's only one and he's on by Zoom.
Yeah, he's on, so
That's-
the rest of us.
Brian, have you all been out to the property to see it? To see where this is being located? I'd invite you to come out to see. It's a beautiful mountain. It's in a beautiful area that we live in. It's a small rural area. And, if you saw how narrow the roads are themselves, it would be good for you to come out to see exactly where this is being proposed.
All right, I mean, I don't mean to cut you off, but we're only in work today, so if you have a question.
Well, I mean, I
ask
would
a
go on,
question. If not, then
no, I'll wait for the engineer to ask other questions.
we'll take it under the.
But I welcome you to come out and see the area that you're
We're
talking
trying
about.
to wait between wanting to know and also trying to be impartial by not knowing too much. So it's the thought.
Right,
That's good, okay.
And I certainly know Tom's gap for it.
Take care of it.
right.
Any other questions, Ben, at this time?
No, I have some statements I'd like to make.
All right, well, that would be your testimony that you
Okay.
could present when we get to that side of the case, so. All right, Mr. Cohen, any questions?
Yeah, I just have a couple questions.
Okay.
So, am I correct in understanding that you only own one inpatient drug and alcohol treatment and rehabilitation facility in Georgia?
I do extended groups on site now, in Georgia. With sober livings.
But this original one that you purchased in 2016, are you still an owner of that?
I'm not,
How long did you own that facility?
4.5 years.
And how big was that?
In terms of acreage or beds or both?
In terms of beds?
110 beds.
110, so roughly just twice the size. Why did you sell that facility?
It was 4.5 years of 14-hour days, and it's very taxing And so I got out to do outpatient, which is less taxing, but less rewarding, and I can certainly help people by being on site and, yeah, as an operator, as opposed to right now, you know, we have outpatient, we've got groups, but I really can't affect the population like I'd like to.
And you mentioned that you have 15,000 outpatients that you're currently following?
1,500.
1,500. Okay, in Georgia. So you're following them by what technique? By Zoom, by somebody's
They're
providing
active
information?
funds, they're active funds.
Active fund. Do you have any, I guess I'm a little surprised that you would have purchased this facility, is it reasonable to ask, because you make a profit on that facility?
That's not reasonable.
Okay, okay. Understood. Do you have any idea how, given how difficult it was to maintain that facility, do you have any idea how long you plan on owning this facility? Before you sell?
And if you know, if you don't know, then your answer is simply, I don't know.
I mean, why I'm getting back in is I miss the day to day, where I work and affect people's lives. And so, yeah, I realized when I was not doing it for a year and a half, this is what I missed, this is what I'm good at, and I intend to get back in. Here I am.
Okay. Given that this is currently a $42 billion industry, and anticipated in 2025 to be a $53 billion industry, are you in this for profit?
Objection, I would be shocked if he wasn't in for it.
Okay. I just wanted to bring that to the attention of the world. Thank you.
All right, now, to the board, if you have any questions, if not, then we'll jump to council to see if she has any redirect.
All I had were already answered.
I'd like to see that 911 report, if there's doesn't even have to be a copy of the evidence package.
I'm gonna check, I don't believe it was entered.
It's not been entered into evidence yet, we can't look at it. Or any other questions? Supervisor, if you can hear me, do you have any questions?
I have one quick question. It's Brian Barrett.
Go.
Can I ask if you have any board members that work with the Healthy Minds Treatment Center and the Water Gap Wellness Center?
I think you've asked me whether or not there's, again, any connection between Healthy Minds and the Water Gap Wellness Center.
Whether you would have any employees.
Well, I'm asking directly if there are board members that serve on both entities.
They're very good, okay.
Yeah, the answer is no, there's no overlap.
And never has been.
No, I was never part of Water Gap Wellness, never made any money, never invested, never worked there.
Okay, Supervisor Barrett, any other questions?
Not for me right now.
Okay, very good, thank you. All right, council, do you have any redirect?
Just a couple of simple regrets, if I might. Dan, Mr. Ward asked you, about, the time that you intend to spend here in respect to your oversight of the facility, and you implied that perhaps it implied that you're not going to be on site 24/7, and so there's going to be times where somebody else would have to be in charge of oversight. Is that, in your experience, generally typical of how a business like this might operate?
Yeah, I mean, you can't be there 24/7. It's a very difficult job. And a difficult situation, right? People come in that are addicted to drugs and alcohol, very emotional. And so, yeah, you can't spend 24 hours a day, 7 days a week there.
And so in addition to yourself, is it fair to say then you will have a staff of individuals who are trained, and licensed as appropriate to be on site, operating the facility when you're not there?
Of course. And you know, the state mandates these ratios of employees to clients. So you can't exceed that. Your clients, the ratio with clients, like 6-to-1, 7-to-1, you can't exceed it. So, yeah, it'll be well staffed and there's a talent pool around this area. And yeah, I intend it to be just as big as my last project.
And with respect to that, you indicated there are state requirements, with respect to staffing levels and like, that's true of any facility of this type, is that right?
In this particular state of Pennsylvania, yes.
So you're living under the same, rules, regulations and requirements as any other facility, you have to operate.
Yeah, I think it is, but I think I know where you're trying to go, just rephrase it.
Sure. So because you are licensed by the state, are you then obligated to, follow the same rules and regulations as any other facility of this type would be obligated to?
I am.
Additionally, you heard Mr. Ward raise some concerns, and we had a bit of back and forth about, drugs and alcohol, on the premises and the ability of someone to procure or somehow, bring those materials onto site. And again, just based on your general experience, is that generally true in any of these kinds of facilities, that there may be some level of that?
I mean, when someone comes in, they have a bag search and they have not a strip search, but onto their undergarments and they're checked and for drugs and or alcohol. So very rarely does it get through. On family days, people are checked and that would be very rare that a family member would actually bring drugs or alcohol to their loved one that's suffering from the disease. But yeah, I mean, there are attempts to get drugs and alcohol in there. Alcohol's hard because it's easily visible, but there will be attempts. And there's other ways to combat that as well.
And will you have policies and procedures in place to deal with that should that come up? Should somebody attempt to do that?
Right, and even sometimes you could have a dog, a sniffer dog in there as well, if you thought that drugs were acting making it onto the property.
And then just one final question, I just wanted to refer back to objective 1, this fictitious name registration. I don't know, I'm not sure if the board has a copy of it or not, so I just wanted to ask you for clarification. You did not sign this document anywhere, is that right?
No. It's my assertion, I know Michael Burke for many, many years, and they needed someone that was a seasoned operator on an application.
So you're surmising that that's,
I had not,
That's how you got there.
never signed anything.
no other questions?
Do you believe there's any recross, Mr. Ward, based upon that it's just department redirected?
Single question.
That's
That-
okay. You
that
got it.
document, the 2018 fictitious registration document, that's your name on there, correct?
It is,
Okay, that's referring to you. Nothing
it
else.
is my name.
No further questions.
Okay. Again, now, Ms. Shine, any questions on recross based upon what you just testified to, this little snippet about what you just said about 24/7 alcohol being brought to the premises, you said. Any questions about that?
Yes,
Okay, come on up.
I'd just like to really know, I know you can't be there 24/7 if this was ever approved. Are you going to live in our community here?
I would, yes.
So how would you manage the clients in another state Do you counsel them one-on-one directly, or how would you manage that? Seems like an awful lot of.
Right, I mean, I have a chief medical officer in Georgia running the operations there currently. I mean, I'm there 5 days a week, but the new project, again, I said I wanted to get back to the day-to-day of managing the inpatient facility. I have the greatest impact on people's lives.
Were you approached by Sean to come to this particular property? Or did you look at other properties before you settled on?
Check for that question. It wasn't what he was asked on redirect.
Uh-huh, okay. I just was curious if you're gonna live in a community, or you're gonna have housing on site for yourself, or, you know, how that's going to.
No, I will live in community, yes.
Thank you.
All right. But Brian, any questions on recall, based upon what was said on redirect?
Yeah.
I haven't. Okay. Now, council, I'm sorry, supervisor, any questions on recall based upon what was said? Okay. So then, we are through with the testimony of, Mr. Harvey. By the way, just so the citizens should know, you're not gonna be left out. What we do is we wait till the very end of all the testimony coming in before we allow for public comment. And then we do that purposely because there may be some questions and some answers given during the testimony that you were gonna ask a question about, and you say, oh, okay, now it's been answered. I don't have to ask that question. So that's why we wait to the end. And then if anyone wants to give comment, they will be able to. So don't think that you will not be permitted to do that, because you certainly will. All right, Mr. Chair, it is approximately almost 5 of 8. I am sure that, well, let me ask, do you have any witness that can be done in 5 minutes?
No, I was gonna suggest that we may want to wait and hold our next two witnesses.
So unless the board otherwise disagrees, I would simply recess the hearing for tonight for another day. Now, if you want to set a date certain and time, you can. This we don't need to re-advertise. If you don't want to do that, then it can be re-advertised. You can do it within 45 days, and I would tell you that, at least for my schedule is concerned, forget the rest of December. I mean, I'll take a look at January, but that's your call. If you need a December date, I'll just try to make myself available.
January, our regular meetings are the 10th and the 24th. Or Wednesdays at 6.
So the 10th would certainly be within 45 days. 24th might be outside, so.
You want to go off record to discuss this?
Yeah, it is all right, I'm sorry. So,
I currently have a conflict on the 10th. We would give you a waiver through the 24th if we need to do that, certainly. If the 24th does not work for everybody else, I can move something on.
that's fine. I'm available the 10th, not the 24th.
You're available the 10th, Charlie. Chuck, how about you?
So
That's okay. I can move something around on the 10th if that works for everybody else.
So we're saying January 10th?
Yeah, that'll certainly work for us. That's our regular meeting.
That's okay.
Oh, I'm sorry.
This one would be better.
Oh, okay, that's also.
I'm supposed to be in North Carolina.
On the 10th. Okay, 24. So,
I haven't done the math. Let me do the math. Maybe we'll still be within the time frame. I don't know.
and if not, we'll give you a rate on this.
13, the first one is what, 18, right? And then we add 24. Probably that is 42 days. Okay, we probably don't even need an extension.
That's good.
Now,
January 24th.
I have a conflict.
Yeah, I know you do. Well, I think we'll. Charlie is our planner. I don't think it makes sense to call him ahead of the engineer, so we'll assume on the 24th, we'll call our engineer.
And let me say again, Brian Barrett, after the end of this year, I'll no longer be serving as a supervisor. So
You'll have somebody else in that seat.
Yeah. Albert,
Right.
gentleman, right?
Okay, and so we would, and you've been here all night, so we would have no objection to
Meeting
this.
is the same, so,
So January 24th.
Yes.
We're agreed on.
okay, January 24th at 6 p.m. will be the next. Petition of the. Ms. Shaw, you had a question?
Yes, as far as I'm not available, obviously, I have no real importance in this whole scheme of things, other than to be able to hear what's going on. Is it available on Zoom?
Yes.
And it'll be posted on the township,
Yes,
the calling and all that information?
we have a couple of, I assume your neighbors on the Zoom right now, so. We do want that for sure.
And just so we're clear, the record, 45 days, and if it's 30 allowed.
If it's 30, I'll give you.
Well, I think it's 25 days.
Nothing to do with the hearing, but I would just like to thank Mr. Barrett for his service.
Here, here.
Thank you.
Sir, may I have your name, please?
Bob Markey?
Thank you.
I just want to add a note to that, you know, Ed Koch had a bridge named after him in New York, Robert Kennedy had a bridge named after him in New York. And when we open our new, Marshall Street Falls Park, we intend to name a bridge Brian Barrett Bridge. I hope you can be opening, Brian.
Okay.
So we're all, the next meeting will be January 24th at 6 p.m. here at the National Building.
Yes. And we have 1 2 minutes.
And we'll take about 5 minutes or so, depending on. Something will be, we'll be here for the, whether these meetings will last.
Could have been John Fisher. Now we were there. Huh? Oh. 90? I was gonna bring his name up.
Well, I was just thinking the thing, I don't know why you're listening to. But by the time it comes up for a decision, he's gonna be in there. It should be it.
Leave for Florida on Friday, so I don't know if I gotta come out a little bit.
All right. So. We're doing the minutes of the November 8th budget regular business meetings. Do I hear a motion to approve both?
Motion to approve both minutes.
Motion by Mr. Levenheim, second by myself. Question? All in favor?
Aye.
Aye.
Brian's still there, or is he gone?
I know, I'm here, and I missed that. Jacob, what did you just, new business?
Yeah, that was the minutes of November 8th. Budget and regular
Oh.
business meeting.
Okay, fine. Well, I'm fine with both of them.
Okay, all in favor?
Aye.
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 Okay. Obviously, we had that public hearing. Let's get below. Solicitors.
Yes, my report was really gonna complex to 2 months because I did not get one out in October. So there were 3 meetings in October that I attended, 2 meetings in November. I received and reviewed a sketch plan for a 5-lot conservation subdivision for Titus and Olenek, and I think that's on the planning commission agenda for planning commission to review. I also reviewed a shared driveway agreement in the finished preliminary final major subdivision. I prepared some additional revisions to the land development agreement and stormwater agreement with respect to Smithfield Gateway Phase 1A-2, which is the law. I know some things have come in the last couple of days. I haven't had a chance to look at them, but hopefully I'll be able to get to those so we can keep that project going. I also reviewed the plan and the tower removal agreement for the cell tower project that was on record. And I also reviewed the development agreement and stormwater agreement and other documents with respect to the Shawnee Valley PRD. I prepared the zoning ordinance amendment to remove the inpatient residential drug, alcohol, and substance abuse facility from the R-1 zone. And I also reviewed the enforcement notice and other documents that were received with respect to the Mountain Manor racetrack case. And I also reviewed the documents and other paperwork with respect to preparing a new hearing date with respect to the matter we had this evening, and various legal research, along with preparing documents and an answer in a new matter with respect to the Shawnee preservation lawsuit. And that being said, that's pretty much what occurred over the last month or so. Right.
Thank you very much, Ron. Engineers report.
I just have one item, the Green Lake O project, this pre-construction meeting is scheduled for next Thursday, December 21st. So things are moving forward. Shop drawings were submitted, they were approved by Michael Baker and sent back to the contractor, so we'll get lead times during the pre-con meeting.
That is nice to hear.
It is good to hear, yeah.
A long time. Okay. Next is the consent agenda, which includes a number of items acting on recommendations from professionals, including the township manager with 2 personnel items, the employment package for the conservation and recreation director, proposed candidate Alex Jackson, and the administrative coordinator, proposed candidate Diana Salvi. For the township manager, in accordance with the township personnel manual, there is separation of Smithfield Gateway escrow accounts per the request of the applicant. There's a request of other escrow funds from the closed dormant account and emergency payment for Bushkill Emergency Corps, and as Misty mentioned, the Green Light Go construction agreement and the volunteer tax credit eligibility list for Marshall Street and Shawnee Park.
Make a motion to approve.
Okay, I have a couple of comments. Number one, I vote against the purchase of the John Deere loader. I have no idea what the declaratory judgment action is. Robert, maybe you can help me there, or Jacob.
Yeah. Between Robert
Which one do you want?
and Ron, you want to talk about the declaratory judgment that you're talking about?
The declaratory judgment is, taking the position that safety is the concern and the province and the sovereign right of the supervisors. And that, anything, in this case, it's, speed bumps that were installed on Wyndham, Resorts property and also on Charlie Valley owners property, that, we have the right to say that whether they're safe or not. And any other HOA, any other PRD, any roads that are publicly used in the township. If somebody wants to, put in their own unsafe, speed calming devices, well, if they put up a gate and they only let in residents, they're perfectly capable of doing whatever they want. But if it's a public access road, we maintain that we have a sovereignty over it and we can enforce safety. Brian, what or did I explain?
Yeah, well, the issue, Brian, if you can hear me, is that, again, the Shawnee and the Wyndham developments have these speed bumps that our township engineer has determined to be dangerous. And I think there's also a bus stop that is maybe creating a problem in the Shawnee development. So that issues have been raised, and their position, when I say their position, the developer's position is that these are PRDs, they do not have to follow the township zoning ordinance, they don't have to follow the township subdivision ordinance. That's all true. We believe they still have to follow and be answering to the township's requirements to protect the health, safety, and welfare of residents, especially when the streets and roads are being used by the public. If those streets and roads were locked and only the people living within the development could use those streets or roads, perhaps they could be right. Even then, I don't know if I'd agree. But here, the general public uses those streets and roads such that we believe we need a judge to tell them we have a right to do that. And that's what the declaratory judgment action is. Basically file a complaint in court saying, we don't know if we're right or wrong. You, judge, declare or tell us whether or not we can do what we think we can do. So that's what that is.
Okay, so I'll pass on that one then. Okay, again, I don't think we should do it that way. So I guess my vote would be no.
Okay.
And another authorized separation of Smithfield Gateway escrow accounts. Can somebody address that for me?
They're separated, well, they're currently all together, this would separate them by path.
In other words, Brian, there's a Wawa pad that Wawa wants to start construction on. There's another pad behind it, which was tied into it as two pads in the same escrow agreement. What they want to do is separate those pads so they can go forward with Wawa because they don't have a tenant for the pad behind that.
Okay, all right, thank you.
All right, so I seconded, is there any other comments? All in favor?
Aye.
Aye.
Brian, you're an A?
Nay.
Okay. We covered the public hearings, now we're going to move Mr. Olmsted, who has a Smithfield Gateway update and a request regarding the Wawa land development plan. And for the record reflect, he was here for the other part of the meeting.
We're asking for a reaffirmation of the approval for phase 1A2, which is the area that's bounded by Smithfield Lane, Music Center Drive, 209, and Mosher Farm Drive, where the proposed Wawa is going to go, and then there's also an adjacent pad just north of the proposed Wawa. that we do not have a tenant yet. So the reaffirmation would, be on this plan, would be to actually remove any proposed development as shown on the plans. Is shown on the plans at this point in time related to that parcel, so that those improvements are not bonded yet, since we don't have a tenant. And the note, I'll read it right from the plan, it says, the proposed improvements to serve condominium unit B, the shaded area on the plan, which I believe everybody has a copy of, which includes a parking area, driveway, utilities, landscaping and lighting, but not stormwater improvements that also serve the area outside of the condominium unit, are not part of the approval, and the developer is required to submit a plan for this area to the township for approval before any construction can take place. So that means that once we do have a tenant for that facility, even if it's laid out exactly the way it's shown on the plan right now, we would have to come back in with a new land development plan for approval for that. So we're asking for, because we're trying to get construction started on the Wawa, actually within like the next 2 or 3 weeks. We're asking for a motion to reaffirm the approval from April 26, 2003, with the changes I've got noted. And I actually provided a proposed language in emails to the township. If you want, I can read through that motion. All right, be it resolved that the Board of Supervisors of Smithfield Township hereby ratify and reaffirm the final land development plan approval of the Smithfield Gateway Phase 1A2 final plan approval of April 26, 2023, with the clarification and the exception that the final land development hereby approved is limited solely to condominium unit A or the Wawa project. It does not include final land development approval of any improvements to condominium unit B to the north, referenced as condominium unit B on the partial site plan for Smithfield Gateway Phase 1A2 as prepared by Langen and last dated December 12, 2023, which is referred to as the final plan. Any improvements depicted on condominium unit B as depicted on the final plan are not part of the final plan, the final land development plan for approval, hereby granted for Wawa improvements on condominium unit A. For the avoidance of doubt, a separate land development plan application will need to be submitted, reviewed, and approved by the township and other regulatory agencies as required before any improvements related to the development of condominium unit B can proceed.
You need this as a note, or would a letter with that language suffice for the tenant? For the, do you just add a note on the plan, or would a
Yes.
letter, okay.
Yeah.
Right.
Yeah, I did review this with, John Kressler, and after some discussion, we felt that this was the best way to approach that. And I want to make sure everything is just above board, because when we provide the letters of credit to cover the improvements, there will be no improvements cost bonded or financial security for that improvement. So that's why we wanted to make it clear, the clear distinction to protect the township going forward.
You know, the engineers wanted that, I don't see why they would have, maybe I'll wait for the run since 90 seconds away.
Doug, did you look at whether the full height curve was provided in the cost estimate? In the
Yes.
reference thing?
Yes, that line will go all the way across.
Yeah.
When we develop that site, we would have to, do new.
Yeah.
curve.
Okay.
So that would be my proposal for the, proposed motion as far as the reaffirmation of that is concerned. Obviously, Mark will help me put this motion together. This is no engineering, there's a lot of legalese.
Yeah. Do you want to go through the other two real quick?
We can do that. The second one, be it resolved that Mark Wolf and Land Services USA LLC, which is the title company, are hereby approved to serve as escrow agents for the plans and documents executed by the township. The escrow agents are hereby authorized to release and record all escrow papers upon delivery to the township or Ron Karasek Esquire, the township solicitor, the financial security required to be delivered to the township in accordance with the terms and conditions of the development agreement between the developer and the township. I think this is the same thing that we did the last time around with Mark Wolf, because there's a mountain of documents that will end up being recorded. They have to be recorded in a very specific order. So I'm asking that in a separate motion that Mark Wolf and Associated Title Company would allow to serve as an escrow agent to hold those. And we thought we'd best cover that with an actual formal motion to solidify that. And then the third item is because it's intended that there's already some equity partners that will be involved in this project. And the third motion is to be further resolved that the township supervisor hereby consents in accordance with the development agreement to DEPG Mosier LP's assignment to the assumption by Smithfield Music LLC of DEPG Mosier's rights, title, interest in the final plan, land development plan, and the stormwater management agreement. So I mean, we could transfer from DEPG Mosier into this new entity, and to be honest with you, it's basically the same players. They just have a separate entity that's being set up. But the way we have the development agreement set up is that before any assignment like that is made, we have to have permission from the supervisors. And again, this transfer wants to be made at time of closing, so we're asking for that motion for the approval of that. And there's some, Ron has to go through and finish up a review of some documents that he referenced that Mark has sent him over the last couple of days.
Oh, it's in my part, engineers. These recommendations, Ron, do you have anything to add?
I haven't read them yet, so I would not give them my blessing, other than to tell you that if you want to approve them on condition that they meet my approval, so you keep it moving, that's fine. Like I said, I'll be able to look at this additional documentation so to keep the project moving. So I'm not happy to do that.
We're not opposed to that, so we just add, to these proposed motions, and subject to a final review by the township solicitor.
Sure, okay. Well, I have no problem with that, so I move that we approve 3 proposed motions, subject to the township solicitor's approval.
Second.
Motion by myself, second by Robert. Questions or comments?
Oh,
That he's approved them, will there be some sort of correspondence or documentation?
Favor?
Aye.
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 In terms of just a general update with respect to the process, and it'll be a very brief update. As we said, we're supposed to be having closing for the financing for the construction of the Wawa before the end of this month. And it's expected that Northeast Side Contractors would remobilize into the area and start construction in January to get the path for Wawa and its contractor to come in to do their work. Brian's work, Brian Wynot, president of Northeast Side Contractors, would take about 4 months to do his work. And Wawa takes about 5 months from when they mobilize. And there's already been an agreement with the parties that if they can cohabitate on the site at some point in time in order to accelerate that
Might not
schedule.
take 9 months then.
It's right now, 9 months is, the outside, so I think the safe assumption is by
Late summer or September.
that is correct.
Okay.
That they would be operational, and I think is
And as you saw, the traffic signal became operational as of
I saw
yesterday.
that today.
There will be, the contractor's doing a little bit of cleanup work right now. But basically, come the end of this Friday, is going to be off-site until the springtime, where he will come back, do some more cleanup. And because, what'll happen is that the entire work area will have a brand new coat of 9.5 millimeter, put across the whole thing with, new line work, so. It's just that we ran out of time before they had the ability to do that. And there's, we're extending, there's a retaining wall in front of the Dairy Queen. That's gonna be extended around the corner into, the driveway. And we'll stop at a, wall that'll go behind the one.
Is that driveway still gonna be open or is it?
Oh, no, driveway, yeah, it's open, so they're all open because the final signage is already there. As a matter of fact, I think the guide rail's already in place, so if you're coming off of 80, the driveway that's between the car wash and the Dairy Queen is now only write-in only. And the signage is already there that you can't go out that direction, and you can't anymore because the guide rail is actually, and so that you have to use the traffic signal. And the
So that
store,
winter, that's right in, it's not out at all.
no,
That's right.
it's only right in.
Yeah.
The original permit that was granted to Frank Riccobono for the odd lot, had a stipulation on it that once the traffic signal became operational, that was supposed to turn into a right in, right out only. So the signage is there, so that people can start to get used to it. But in the springtime, when they remobilize onto the site, the pork chop, which is the raised concrete curb, will be going in the center of that to help channelize and make it much more difficult. You can't fix stupid, so there will be some people that will, depending on the time, there's no traffic that'll make a cross-traffic movement, but the intent is there's no cross-traffic movement. Because, in the springtime, they'll also be putting the pork chop on Music Center Drive.
Right.
So you can go right in, right out. But if you want cross-traffic, you'll have to use Smithfield Lane onto Mosher Farm so that you can do. The only cross-traffic movements in front of our project to it will be the traffic signal.
Is the traffic signal now, on demand for the cross?
There's some work that has to be done as part of the Go Green work.
Right.
So hopefully your PennDOT project will go smoother than ours did.
That's all.
Because our project was supposed to be done in one construction season and it'll end up being 2.5 construction seasons.
I see, it's not relevant to life. Where is the Popeye supposed to go again? I know that you announced them. I couldn't.
Popeye will be going, right across the street from the Wawa.
Okay.
There's the empty lot between that new signalized intersection. There's an empty lot between that and the odd lot parking lot.
Right.
So it's in that small area that, sometime this winter we'll be coming in with a land development plan, for that.
South side, I'm sorry.
Pardon?
Your south side?
Yes,
Down here.
yes.
That's what I thought, but I couldn't remember it. Like, it depends on the day. You see spots in different spots and
Yeah, well, right now it's served as a staging area for Leeward when they were doing their highway.
it's a similar layout on, I think I remember a preliminary or some sort of sketch of that from beforehand, right?
Yeah.
So the setup is pretty much the same as the condominium B that's on this existing.
That is correct. Does anybody have any questions?
No, thank you.
Right, thank you very much for your time.
Doug, if we don't talk again, make sure you have a good holiday, okay?
You also, and if you have any questions on any of that stuff, you can work.
I gotta do some reading, of course. What else is new?
Yep.
Okay, next is the Shawnee Valley Plan Residential Development Annual Update and Extension Request. Proceed to that.
Hello, I have a comment. I just want to know, what are you guys doing about this extension? this is a very old plan that, how can you extend something that's like almost 25 years old?
Well, we're about to get to that, so let's hear from the solicitor and review the request before we move to that, then we'll take comment on that.
I just want to make sure you heard me. Thank you.
No problem.
Yes, Mr. Chair, the letter is a requirement of the project very beginning, where that every year there has to be an update provided to the township as to the status of the particular plan, what's going on with the phases, how much is being done, what's not being done, and traditionally the township has always granted these extensions, because I think one is made almost every year.
I know. And you say traditionally, so every year we're renewing. This is crazy that you keep renewing something. If they haven't done the project yet, they don't know what they're doing. That's what I'm trying to say. If they haven't figured out how to do it yet.
Excuse me, I think the reason they haven't done the project is because it's continually held up in court.
Why? Because it's a problem.
You can ask the people who wanna hold up at SPS. We don't know, we're not involved in that.
I would make a comment that that's incorrect. I have a different opinion on that.
Correct.
This is, okay. Forgive me, I understand that, but we haven't actually gone through the entirety of the request. We'll take comment before we entertain action.
Thank you.
I'm looking at the letter,
Correct. It's the same.
and it's pretty much the same as it's done traditionally. It tells us stage 1A completion, talks about stages 2 and 3, and then the sale of stages 1B, and he says 6. I thought it was 4, but by Wyndham. And then they are putting in the information regarding the 2005 amended tentative plan.
Again.
And let's see here at the Board of Works, and it says here at the board's December 28, 2021 work session, the board approved of the following development schedule. And they are now providing an update with respect to that schedule. Which
So they're just changing the year. They're just changing the years.
Joanne, you have to wait till we're done going through the nitty-gritty before we start comments. That way we can keep this smooth and efficient.
I'm following along in the letter. Go ahead.
All right,
Sorry.
that looks like that's okay. At the very end, it talks about updated projected development schedule, which they put in those new revised dates where they kick them out basically by another year or two. Again, this was before my time, so I can't tell you what their duty is or is not proper. All I know is that they're required by the plan to submit an update every year as to what they're doing, and if there's any changes, what the changes are.
Isn't that part of the requirement of the MPC for PRDs that are actively in construction or active projects? There was no original timetable given to do. That's why this is done.
Well, yeah, that's exactly right. They could have said you're gonna get this done within 5 years or 10 years or whatever, but that wasn't done when the plan was adopted back in 2008. So we now have to live with that. 2007.
1985.
Okay, 1988, right? Even earlier than that, sorry. So anyway, the township did request that, so I don't think we can do much with it, but certainly you can entertain comments.
No, I'll just say it's a mischaracterization that SPS has continually held it up in court. That's not true. And this latest court filing was at the request of the township. The solicitor suggested that we should go and get a declaratory judgment, so we did.
And I agree with that.
Okay, well, I don't understand why there would be a justification to not grant the request. every board has done this for, at this point, literally decades. But
It's
it
ridiculous.
doesn't actually change the substance of the plan. The litigation's still ongoing, and we hope there will be a resolution, like Martha said, we asked for that. But I don't understand why that would change this in the meantime.
Well, if you wish, you can ask the applicant and say, please provide the basis for which you are requesting the extended time. This way, then we see whether or not the applicant, not necessarily the applicant, but the developer agrees or does not agree with why the extension is being requested. So you can do that. You can table the matter and request that. I'll make a motion if you want to. If not, you can just approve it.
So it's the same as previous requests. I think it's pretty clear in asking why it wants the approval. It's like simply, it hasn't started, it's not done. They want more time, but they're not, they're not going to move in today and do the work, but you wouldn't be able to complete, I don't know. Right? Didn't we approve one in 2022?
We approve every year.
But it only mentions the last one is 2021.
So
So I
every
would.
year.
There's a couple typos. I don't know if you want me to tell you them, but go ahead.
Go ahead, Joanne. Go ahead.
Above Exhibit A, you see all the CCs. Did anybody catch a typo there? And exactly, 2021, is that when you had your last work session on this? So if it's supposed to be an annual, and then over here you had August of 2022, up above it, the amended 05, right above that, on page, the page that Ted signed. And there was another one somewhere else I found. And then these properties under Exhibit A, so basically they're just changing like the stages and the names. And then they have these site sizes, 99 acres, 95 acres, 105 acres. So those are the three big parcels of each section there. But I think there's correct either, but that's not my concern. My concern is why year here, I guess traditionally was the best word that was used. Traditionally, well, to extend a plan for 20 some years is ridiculous. It's not traditional, it's ridiculous. And I think that if we had people in our township that were more concerned about what's going on around here, but we have like 7,000 people and we're lucky if we get 20 people in the room. So it's like you guys are just like running the whole show and spending our money that we work hard to pay our taxes. Now they're going to go up $400 and some per household. It's not right. We need to spend our money more wisely.
We don't go up, but you don't get ambulance service and you don't get fire service. How about that? You prefer that? Because that's why your taxes are going up.
I can't. Okay, why?
Yes.
Because our budget. Because of the budget.
Go back to the people who signed it in 2005.
Correct.
That was another board. We had nothing to do with that. And yet we're continually being drowned into lawsuits that are between SPS and the developers. And I'm really sick of it.
Supervisor, you're the supervisor. Who else can we go to? You have to protect us.
We didn't sign these documents in 2005 or 2007. Whoever did it, I can't answer for them, but personally, I think it was the wrong decision to make.
All that said,
you can make a decision now. You can make it. Is Martha still there?
She's here.
Martha. Yeah. So what's going on as far as like the buffer around the lake? Is that still protected? Do you know?
It would be reduced. They won't adhere to the buffers as in the settlement plan because their position is they don't have to follow the settlement that we agreed to.
How could you not follow a settlement? It's a court order. It's a court settlement, not a township. It's higher. They have to abide by whatever the court says.
So that's
And
why
why
we're
would,
waiting for the declaratory judgment.
you know, the township makes parks here and parks there. You should buy down at Sun Mountain. That would make a beautiful park. That's what you need to do. Give this guy his $100,000 back and make that a park. You
We
want to
can't
put a
buy-
park? What about
We
a
can't
park?
buy because of the covenants in Shawnee Valley Owners Association that have rights to the park and to recreation in the park.
Well,
It's not available to buy if we wanted it.
well, what is Hunter going to do with all that? Is he
That
going
is
to,
up to whatever the court says. That's why we're relying upon that statement.
is he going to splatter it with homes? If
We-
not, then the township should buy it.
Okay, well, we'll look at that, but look, all right. For the purposes of this item, which is the relevant. I don't. Doesn't seem like there's just, it doesn't really require.
All they're
additional.
is giving you an update and changing the years, a couple years. So next year they'll come in and they'll probably use the same template and just change the years. And that's what's traditionally going to happen, evidently, because this is crazy until somebody stops it. It's ridiculous. It really,
Not approving it isn't going to change anything. Go ahead, Drew.
I had actually asked, some of the prior members of the board why we continue to do this. It didn't make sense to me, and I will not name names who I spoke to. But what I can say is that they looked at me and said, the more extensions we give them, the more likely it is for this project to fall apart. If we refuse to give them an extension, they are suddenly forced to act and we will be placed with whatever we have. But the longer this goes on, and as long as we keep extending it, the more time that property spends is not being built up.
I agree with that, and it's been, what, 20, 30 years? How long has it been? 88. No, 88.
oh my God.
And it just keeps going, but nothing gets built.
But they, what are they going to start with? They don't have anything to start with. There isn't a plan that they can go in and cut roads and build houses.
Yes, there is a plan, but it's an antiquated plan. It was a plan that was approved in 2000 by the supervisor.
Correct. So make them come up with a new plan with today's, you know, environment. The water situation is ridiculous. I have water running all over the place. The water table is so high. Go now and walk all along there behind the lake. I bet you won't, not without hip boots. I mean, the water is unbelievable. You can't get approval to build a home in those wetlands, and you're going to move the wetlands. Yeah. Okay. That's another whole topic, but I'm just saying that things have changed over the 20, 30 years that original plan was approved. Those guys couldn't build it. So they sell it to somebody else. Those guys tried to build it. They couldn't do it. They sell it to somebody else. Doesn't that tell you something? It's not a market. There isn't a market to build more homes. This is a beautiful area up here. And what are you going to do with it?
I agree, but we're not in that business of whether we can tell people to build or not. But I'll tell you one thing, there is a suit now being by the Shawnee Preservation Society going to court about this again, but maybe there will be some resolution there. The courts are the best place for this to be resolved.
And they will tell us which plan prevails. They will interpret the plan language and so, but for now, the only option is to consider the approval. So do I hear a motion on the request?
I'll make a motion to approve.
Motion by Mr. Levenheim, second by myself. Any questions? All in favor?
Aye.
Aye.
And I would like also to say,
We have to get Brian's up.
Brian,
No, it's Pam. I have a question when you're ready.
I just want to say one thing. Instead of approving it, can't you table it? You just said something about tabling it.
there's a motion on the
There's
floor.
no justification, but we already voted. There's no justification.
I tried,
Brian,
but it turned me off.
Brian, what's your vote?
Brian will say table it. Table it.
That's not a vote. So you have to vote yes, no.
Or recuse
What?
yourself.
You have to vote. What's your vote?
Who? Brian?
Yes, Brian, the supervisor, yes.
Who's screaming? Is that you, Pride? Hold on.
For the love of God, can we have a normal experience there? Brian, what's your vote?
I have no idea.
I've got a chance to vote then.
Hello, is this, Jacob?
Yes, Brian.
Yeah. Is there a motion to table this?
There was a motion to approve the extension.
Okay,
Your vote is,
I'm gonna vote no.
Brian, every year you voted yes. On the same
Yep,
thing.
and isn't it time? Isn't it time? But anyway, it's a 2-to-1 vote. I'm voting no.
Matter anyway.
You mentioned 205. I was elected in 206, so yeah, every year
We're not
for.
I know
Okay.
your name isn't on that 205 document. I know who they
No,
are.
here's the deal is, and I think Ron hit this. You got so many years to complete it. If you don't, you've got to come back and request an extension. If the extension is not granted, they've got to do something.
A new plan.
A new plan or whatever. Yep. So I'm voting no. My vote is no.
okay, great. All right, Julia, so we do not have the people here, as far as I know, for the post office bridge, correct?
I do not believe.
Can I make a statement about that last?
Here's the phone, ma'am.
Yeah. My only statement is this. Supervisors have no prejudice one way or another on this. We're totally neutral. We are hoping that the courts can decide this because given the long history, given the fact that this was approved by a board that no one can even remember anymore, and we're stuck with this, we just want to say that, to whatever happens, we have no interest or prejudice on either side.
Now, when can I ask a question?
In public comment, we finished that, all right. I'm gonna move to table the post office bridge discussion because the affected individual is not here. We need their input. Do I hear a second?
Second.
Motion by myself, second, that's a vote. I'm all in favor?
Aye.
Aye.
So I'm not allowed to ask a question?
We need to complete the agenda. We completed that time. Brian, what is your vote on tabling the post office bridge discussion?
I vote to table it.
He votes to table it.
Okay, great. Order supervisor report. I have nothing to note. Bills, we have $158,383.63, all in the general fund, and it includes 2 payrolls. Do I hear a motion on the bill?
Motion to approve the bill.
After you have that second, can I just say
Okay,
something?
motion by myself, second by Mr., or sorry, motion by Mr. Levin, second by Mr. Yes, Brian.
My question is, looking at my bill, I don't think the September bill was paid. I didn't get September out until mid-November. You had no second meeting in November, and then I issued bills for October and November.
Okay.
So I think the September bill is still owed.
Okay.
I remember sending in.
Ron, they're out of money. That's their problem.
No, I just think that it was just, maybe this, so just check. I mean, my bookkeeper could be wrong. My bookkeeper could say, no, that we got the bill, we didn't know it, but just check on that because it's significant.
They're behind in a lot of bills, Ron.
That's not true. That is not
No,
true.
it is, dear. Now, Ron, can I ask you a question?
We're not there yet, Pam. Just give us a second to finish the bill. We're on public comment.
All in favor of paying the bills? Aye. Brian, what's your vote? Paying the bills.
Hey,
Cool. Brandon votes, so that's right. 2-1. Fine. Public comments.
I think Pam has
What?
something.
He's sitting right next to me saying nay.
You're not a supervisor.
I know I'm not a damn supervisor. Let's not be an asshole about this.
You lost the election, you know,
Yeah, nay.
by a
Hold
lot.
All right, hold on. Is there a comment? Because if there's not a comment, we're gonna move.
He's not capable.
Pam, I think you said you had a question for me?
Can I ask a question now?
Yes.
Ron, when there was a thing that came before us, actually, Lois was up here to have Brian sign it, where we couldn't figure out what it was about. It was about how the township was always going to take care of the safety of everybody, even a PRH. Was that a setup for what Robert asked for today? Did you write that?
That was approved whereby the township wants me to prepare an action to see, again, if the court will declare, it's very similar to the Shawnee preservation action, to declare and tell the township whether it can tell PRDs, which are a very special animal under the municipal law, they must follow the health, safety, and welfare of their residents with respect to roads. And
so that was done. So that was done for what he wants today to go after them, right?
Yeah,
It was a setup. I mean, it was a setup, and the rest of us weren't told. We weren't explained to it.
Yeah, well, if you've been on it, whatever, it was explained. Brian asked if I explained it.
Now, what I don't understand, Lovenheim wanted to put speed bumps on River and Hollow Road. Why is he against them now?
You got that lie from?
Huh?
Hold on. This is, you know, as Ron says, public comment is not question and response period. It is public comment time.
It's not a time to spread vicious lies that are total lies.
Look at you, little Ron. It's not, I'm not saying why. You know damn well you wanted to do it.
You know,
Okay.
go back to
You were-
your game.
So we were set up. You set the rest of us all up, knowing damn well what Robert was going to do.
Stop. Wait. All right. Any other comments?
No.
You know,
Bye.
your lies on your Facebook page for your 10 people that listen to you.
It's fine. I made a motion to adjourn. Do I hear a second? All in favor?
Aye.
Merry Christmas, y'all.
Yeah, it's no.